Good afternoon, everyone. I'm Dorothy Starrow, and it's my great pleasure to introduce to you today our keynote speaker, the acclaimed author, Joe McGinniss. Mr. McGinniss is a man who's had the opportunity to observe our justice system from just about every angle. In his role as journalist and author, he observed two of our country's most infamous murder trials, that of O.J. Simpson and the trial of Jeffrey MacDonald. Mr. MacDonald was a Green Beret physician who was found guilty of savagely murdering his wife and two small daughters, and was the subject of Mr. McGinniss's book, Fatal Vision. Our speaker has endured the tribulations of being a defendant in a civil action in which Jeffrey MacDonald, somewhat disgruntled, sued Mr. McGinniss for having the effrontery to write a book suggesting that, in fact, Mr. MacDonald was guilty. He's also had the tribulations of being a plaintiff in an action against his insurers involving that very same trial and book. He was only 26 when he hit the New York Times bestseller list with The Selling of the President, a book about the packaging of the 1968 presidential campaign of Richard Nixon. Never afraid of controversy, he recently gained notoriety when he accepted the house next door to Sarah Palin while he was writing The Rogue, searching for the real Sarah Palin. And today he's camped out in our Superior Court in Hampshire County, which is the subject and the setting of his latest work, 15th Gothic Street. And the first installment of that book is hopefully due out next month in electronic form, so we should all be looking forward to that. For the past several months, he's had the opportunity to see our justice system here in Western Massachusetts at work. And I can think of few speakers in a better position to comment on this year's Law Day issue, access to justice. So with no further ado, I give you Joe McGinniss.
Thank you. I found that justice is actually something it's maybe on a higher plane that occasionally intersects with the law, and those are the happiest of times. But my wife just yesterday came across a quote from William Gaddis, the terrific American novelist, a book he wrote in 1994. He has a character who said, "Justice, you get justice in the next world. In this world, you have the law." And it's sort of in the gap between those two, and in the attempts to keep that as narrow as possible by attorneys on both sides of civil and criminal actions, that provides the tension that, and the narrative thread that I'm following through this calendar year in Hampshire County Superior Court in Northampton. And I'll say right at the start that my work has been made a lot easier by the accessibility and affability of the Northwestern District Attorney, Dave Sullivan, who's here this afternoon. And it's an honor to share a platform with Dave, who's done a great deal to make my introduction into the world of, into his world as smooth as possible. And I've already, it's only April, already I've had the experience of opposing the Northwestern District Attorney's Office in court. Last month, I covered the trial of David Fried Oppenheim, who was convicted of child rape, 5-count indictment. He was convicted on all counts. The former director of the Performing Arts Center of East Hampton, accused of having had sex more than 100 times with a 14-year-old girl. and with others who were over the age of 16, so they were not chargeable offenses. But the same pattern of conduct was established, and the jury came back with what, in my mind, what was certainly the proper verdict in finding him guilty. And he was sentenced to a minimum of 5 years in state prison. At the start of that trial, the prosecuting attorney, Linda Pisano, the head of the child abuse unit, filed with the court a series of witness statements that made by the 16 and 17-year-olds who had also been victimized by Mr. Fried Oppenheim. And she did this so the judge would have the ability to discern the pattern of conduct and allow them to testify, even though, as you all know as lawyers, you can't bring in prior bad acts to show a propensity to commit a crime in the future. You know, there are some very specific purposes for which this kind of thing can be used. And to broaden the use as much as possible, Ms. Pisano filed these documents with the court, but asked, given their sensitive nature, that they be impounded. And Judge Roop said, well, I will impound them for the duration of the trial. At the end of the trial, I asked Ms. Pisano if she could have them unimpounded. And she said, that's something you'll have to take up with the judge. So I asked the judge, and she said, well, you have to put that request in writing. So I put the request in writing, saying that it was in the public interest and there was no continued reason for impoundment because the trial was over. And she called a hearing on the matter. And I called Assistant District Attorney Pisano and I said, there's going to be a hearing because what, you're opposing me? She said, well, we have to oppose you. We need to protect the privacy of those who come forward in a sex crimes case. We have to do everything we can to keep as much of their personal information private as possible. So yes, we're opposing you. So I represented myself at the oral argument on my request for having the documents unimpounded, and taking the matter under advisement for a period of time. Judge Roop, a couple of weeks ago, released a 7-page opinion in my favor, unimpounding the documents, saying that, yes, these, because of the First Amendment, public's right to know, there was no valid reason to continue to keep these sealed. I made the point, and I'll make it here again, that what's paramount is the privacy of the witnesses who came forward. These kids, these brave young kids, at 16, 17 years old at the time that they were molested, were willing to step up to testify in a public court, to do the right thing. And I feel, as a father and as a grandfather, I feel very strongly that anybody in that position needs to have their privacy protected. And I have no intention of ever using any of the real names, even though they were, even though these people did testify in court and their real names were apparent to anybody who was sitting in the courtroom. I'm not going to publish them. I'm not going to print them. I'm not going to invade their privacy in any way. I have as much respect for that as anyone. But I did feel that it was important for my telling a coherent story from beginning to end about these events that I have as much information as possible. And these documents turned out to contain information that has enriched my narrative, the results of which you'll be able to see next month on byliner.com. So that was my recent experience gaining access to what I thought was justice, doing it myself. I had a previous experience in Petersburg, New York, after a 1998 automobile accident that almost killed me. It was the Sunday night of Thanksgiving weekend, and I had dropped off my college-age son at the Albany airport. We were living in Williamstown at the time. And he was flying back to college in Philadelphia, and I'm driving home at 6 o'clock at night, and it's dark, and it's late November, and it's a hard, hard rain falling. And as you start to climb that Petersburg Pass that goes from New York State into Massachusetts in the Berkshires, the road climbs steeply, and the temperature drops, and the freezing rain turned to black ice. And before I knew it, my car had slid off the two-lane road, flipped over the guardrail that was supposed to keep it on the road, and rolled down an embankment and came to rest a couple hundred feet down. I was thrown out through the left rear window. It was a Volvo, thank God, because if it had been anything less than that, I would have been killed. But the Volvo had enough support in the steel structure that I went through the glass. And this was a dangerous situation because I'm bleeding from the head. I regained consciousness. The car is on top of my chest. And I can move my arms and legs, but I can feel I can feel the blood coming out of the top of my head. And I can't move. And I'm thinking, gosh, it's a dark night. This road has no traffic on it. I could be in trouble here. Then, miracle happens. Headlights go by. Somebody sees the headlights of my car shining up from down by the creek bed there where there's not supposed to be any headlights. The guy stops. He slides down the embankment, which is already icing up, and he says, "Oh my God, there's somebody alive here." I said, "Yeah." He says, "Look, don't worry, I'm going to get you help. Now, you won't see me again because I can't afford to be here when the police come. We won't even get into that, but trust me." And so off he goes. The Good Samaritan who saved my life. I never saw him again, have no idea who it was. The police do come, and the first person I see is the deputy sheriff for Rensselaer County, New York, and he says, on his radio thing, he said, "Lou, tell them to hold that chopper because this guy's not going to make it anyway." And that's, I was feeling pretty good until then. But the weather was getting worse, and they were talking about flying one of those Medivac helicopters from the Albany Medical Center because it's a 40-mile drive on bad roads to get there overland. But he says, "Tell them to scrub the chopper." And the next thing he does is he says, "Well, see you later, probably in the morgue." And he disappears, and the volunteer firemen with their Jaws of Life machine come in, and they've been watching a pro football game at the Petersburg Volunteer Fire Department headquarters all afternoon with a couple of cases of beer, and they were feeling pretty good and had a chance to use their Jaws of Life. And I feel this blade resting against my upper left thigh, and I said, wait a minute, that's not the car, that's my leg, And eventually they did cut me out of the car. They tried to give me oxygen, but the hose was broken off the oxygen tank. The chopper was scrubbed. An ambulance arrives. They cart me up. I'm still feeling great, I don't know why, but I was feeling, I wasn't even in any pain. They put me in the ambulance. My head is bleeding a lot. That's the only real troublesome thing. And I'm having a great chat with the nurses in the back of the ambulance as we drive back over the icy roads to Albany. They're smoking cigarettes in the back of the ambulance. They say, don't worry, because the oxygen's broken, so it's safe. We can smoke in the ambulance, I'll tell you, Petersburg, New York is not a good place to have a car accident if you can avoid it. But the Albany Medical Center is wonderful. They get me to the ER, and I'm lying there on my stomach, and there's a doctor who's cleaning out the back of my head. I was lying by the edge of a creek, and there's all this, wood and garbage and dirt and stones, and really a deep cut. So he's stapling up the back of my head, and he pauses and says, "Yes, can I help you?" And he's talking to somebody who had just come into the emergency room. It's my friend, the deputy sheriff, and he says, "I went to the morgue." He says, "and I couldn't find you." He says, and he was irritated that he had to come to the emergency room. I wasn't in the morgue where I was supposed to be. He says, well, I've got something for you. And he drops 2 summonses on my back. Failure to keep right and driving too fast for conditions. He said, there you go. Well, there you go. I have to appear in Petersburg court to answer these summonses, or else I have to just pay a fine. I said, I'm not going to pay a fine and say, failure to keep to the right and driving too fast. Driving 5 miles an hour would have been too fast for those conditions. You know, what do you mean, too fast for? So I contested. So I'm fresh from the O.J. Simpson trial, having watched lawyers like Johnny Cochran and Bob Shapiro and Lee Bailey handle things for months. I said, I can do this too. So I go to the night court in Petersburg, and the magistrate there comes in from dinner. He's still chewing some kielbasa and cabbage that he was having for dinner. And he takes his seat. He says, now, what do we got here? And he says, well, driving too fast for conditions. He said, what do you say to that? And I said, well, Your Honor, it's icy out there right now. You know, what's too fast for conditions? If you walk down the courthouse steps here at your normal rate of walking, you'd slip and fall on your, that would be walking too fast for conditions. You can't move at all in conditions like this. I said, how am I supposed to know the conditions? They weren't posted. There was no sign that said caution. I said, I wasn't driving too fast for conditions. The conditions just suddenly appeared. He said, well, what do you say to that, officer? And he said, well, he shouldn't have been driving fast enough to slide off the road. That's all I can say. And I said, if I wasn't driving fast enough to slide off the road, I was never going to get up the hill, So we have this debate. And then the magistrate gets bored with this and says, that's it, forget it. Not guilty. Driving too fast for conditions, not guilty. He says, on the other hand, you can't deny that you failed to keep to the right. My car slid off the left side of the road down the embankment. I said, technically, I did not, therefore, guilty, failure to keep to the right. So it was a split decision. And I felt it was worth the effort. That was my access to justice. But on a slightly more serious note, I was in the hospital for 3 days because they kept waiting to find something terrible wrong with me. The car was totaled. It was just an amazing thing that I survived, but I only had this cut in my head. I didn't even have a broken bone. The cop was not happy, I found at the O.J. trial, which I referred to, that the more money you have, the higher priced talent you can buy. And sometimes you do get what you paid for. If O.J. Simpson hadn't been O.J. Simpson, and the fact pattern of that case was exactly the same, and he had just been an average African-American man in the street from downtown Los Angeles, there's no doubt in my mind that he would have been found guilty. And the trial wouldn't have taken 10 months either. I'm not sure that all credit can go to his lawyers for having the verdict come back as not guilty, because the decision to try that case in downtown Los Angeles in front of a jury that, as I recall, consisted of 11 African Americans and 1 Hispanic. No, there was 1 white woman on the jury, I'm sorry. It was 10, 1, and 1. As opposed to Santa Monica, where there would have been a different racial composition. And a largely black jury was never going to convict O.J. Simpson in Los Angeles at that time because they were white police atrocities against the black community were still too fresh in their minds. And they simply didn't believe the testimony of any white police officers if he testified about a black man. Their life experience, jurors are always told to rely upon their life experience and their common sense. Well, these people did that. And their life experience had taught them that white cops lie. And it didn't matter what evidence the prosecution put on. They spent 6 weeks simply on the DNA evidence in that case. They had a DNA expert come down from Oakland, another one come up from San Diego, a 6-week seminar in DNA. I felt like I was in medical school for most of that time. I talked to one of the jurors afterward, and I said, but what about the DNA evidence? How did you disregard that? He says, well, I could never figure out what that DNA was really all about. He says, is that something like blood pressure? Now, this was after 6 weeks. This is a failure to communicate on the part of the prosecution attorneys. I should say, as a sidelight to that case, that one of the factors in terms of the inadequate prosecution was that the two lead prosecutors, Marcia Clark and Christopher Darden, began to have an affair during the O.J. trial, and that provided a significant distraction. They literally would be sitting at the prosecution table during testimony, and the TV, of course, everybody was watching this on TV, you'd see them, writing notes and saying, well, they're paying attention to the evidence and they're preparing their questions and stuff. They weren't. These were actual love notes back and forth to each other, And there was a member of the prosecution team who was so offended by this that at the end of court every day, this individual, who's also a lawyer, would go to the prosecution table and would clean up all the scraps of paper. And they're now stored in a safe deposit box in a bank in California, all the love notes that Darden and Clark wrote to each other during the O.J. trial. As they're expressing their undying affection for one another, O.J. is getting closer and closer to walking out the door, which he ultimately did. So there was a case where money and celebrity and race, in a way opposite from the way we usually think of race being a factor, did have a large role to play. The other case, in the first murder case I covered a trial from start to finish, was that of Jeffrey MacDonald, who murdered his wife and children in 1970 at the Army base in Fort Bragg, North Carolina. And he wasn't tried until 1979, which is a story in itself, which takes up a couple hundred pages of Fatal Vision. But when he was finally brought to trial, well, he actually, way back in 1970, as soon as the Army filed murder charges against him, he called influential friends from Princeton and Northwestern. He had gone to Princeton University and then Northwestern University Medical School, and he gets the consensus: the best lawyer in the country, the man you need, is Bernard Siegel. This is the man you have to get to represent you. Bernard Siegel, he's the #1 lawyer in America. So MacDonald calls Bernard Siegel in Philadelphia, not realizing that the man he wanted was Bernard Siegel of Washington, D.C., past president of the American Bar Association. Instead, he gets Bernie Siegel, a criminal lawyer from West Philadelphia, who mostly was handling district court arraignments of college students arrested for public intoxication over the weekend. And into Bernie Siegel's lap falls this case of national attention. Oh my God, MacDonald didn't know for years that he had hired the wrong Bernie Siegel. Now, the right Bernie Siegel, I'm sure would never have taken the case. He was not even a criminal lawyer, but he would have been able to make a referral. And it didn't matter at the 1970 Army hearings because the Army just wanted to get rid of MacDonald. They didn't want to go ahead with a court-martial of a Green Beret officer accused of murdering his own wife and children. They just wanted the guy out of the Army. There was enough bad publicity coming down from Vietnam then. And so the Article 32 hearing, which preceded the court-martial, the hearing officer found that the evidence was insufficient to carry it forward to court-martial, and MacDonald should be honorably discharged. The Army washed its hands of the case. And then the Justice Department came along and picked it up, and it took 9 years to bring him to trial as a civilian. He still had Bernie Siegel as his lawyer. By now, he knew it was the wrong Bernie Siegel, but on the other hand, 9 years before, Bernie Siegel had beaten the Army at the Article 32 hearing, so he had confidence, which turned out to be very badly misplaced because his Bernie Siegel had left Philadelphia. He had to leave Philadelphia because there was a question of embezzling funds from a firm he was associated with, and he moved to California, basically stopped practicing law and became a professor at Golden Gate University Law School, which is about the 6th best law school in San Francisco. It was not exactly Bolt Hall or Stanford that Bernie was at, but he comes back and he hasn't been inside a courtroom in a competitive situation for 7 or 8 years, and he just made a complete mess of that case. I mean, McDonald was guilty. The evidence was overwhelming. There's no question about the verdict, but a better lawyer could have made the prosecution work harder to get the conviction that they got. However, McDonald, I'll say this, he's a psychopath, and psychopaths never know when to quit because they always know that they're right and everyone else is always wrong, and eventually it's going to come out that way. He still hasn't quit. In August of this year, in federal court in Wilmington, North Carolina, there's going to be an evidentiary hearing on Jeffrey McDonald's latest motion for a new trial. 42 years after he was first charged with these murders, the case is still going on. The government will have to go down there and answer questions that McDonald is putting to a judge. He's been through dozens of lawyers. Witnesses have died, judges have died. The case goes on. It's like the Jarndyce and Jarndyce from the civil suit from Dickens, the one that goes on for generation after generation. The Jeffrey McDonald case is the criminal equivalent of this. 42 years later, 42 years after he was first charged with these murders, he's still in court. The case is not yet closed. Now, I'm not sure what that says about justice as opposed to law, but the lesson I take from it is that as long as you have money to hire one more lawyer, or as long as there's one more lawyer out there who sees the publicity potential in representing you, you can keep a ball in the air for a real long time. No matter what the Supreme Court's basically, they're saying, you know, you get one chance and that's it, and then you're on death row and then you're executed. Well, not if you're Jeffrey McDonald. He's still serving his time. 3 life sentences. He'll die in prison, but he'll die. Believe me, when he dies, there's still going to be an appeal sitting in some court somewhere asking for a new trial based on so-called new evidence. So, does everybody have the same degree of access to the law? No. But I'll close by giving you a story closer to home. Now, I've been in Superior Court since beginning of January, and I've sat through 4 jury trials that have gone to completion. The first one was an operating under the influence 5th offense trial where the defendant, figuring 5th offense could be 10 years in state prison, no license for the rest of your life, he figured he might as well roll the dice. So he hired a lawyer from Springfield, and he pleaded not guilty. And Mr. Sullivan assigned a prosecutor to the case, a young man named Scott Rathbun, trying his first case in Superior Court. And Mr. Rathbun obtained, quite rightly, a conviction. The defendant was found guilty. Another case comes along. A fellow was found to be in possession of a firearm that he shouldn't have been in possession of, a loaded gun. He had a previous firearms violation. He pleaded not guilty. His case went to trial. He was found guilty and sentenced to 5 years in state prison. And then there was the Freed Oppenheim case where Freed Oppenheim hires the man who's probably recognized as the leading criminal defense attorney in Western Massachusetts, or certainly in Hampshire County, David Hoos, who's also representing Cara Rantala, the Granby woman who's accused of murdering her wife in the first same-sex murder case since Massachusetts legalized same-sex marriage. And Hoos is representing Tony Bay, the accused arsonist who is accused of having set those fires in Northampton, one of which killed 2 people. So Hoos is the go-to guy in this part of the country. And Oppenheim goes to him, and he's found guilty on every count. And yesterday, it was only yesterday, that for the first time in Superior Court, I heard a jury come back with the words not guilty. This was a 6-count domestic violence case where the charges included kidnapping. They went from kidnapping at one end down to punching a hole in a piece of furniture from IKEA with your fist. The piece of furniture cost more than $250. It cost $299 brand new. So it was a felony, just malicious destruction of property worth more than $250. I didn't know until this week that in Massachusetts, the penalty, Massachusetts values property very highly. The penalty for punching a hole in a cheap fake wood door of some garbage from IKEA that you buy for $299, that's 10 years in state prison, which is the same penalty maximum you face for kidnapping. So punching a hole in a piece of IKEA furniture can send you away for just as long as kidnapping can in Massachusetts. In any case, the jury considered the evidence very carefully, and they didn't feel the evidence supported the kidnapping charge or most of the other charges. They found him guilty for punching the door. There was a hole. There was an armoire. They wheeled it into the courtroom. Just sitting there facing the jury, there's this big jagged hole in it. The guy said, yeah, I punched a hole in the door, you know. So he's not pleading not guilty to that one. But it was all part of the same altercation. And they found him also guilty of throwing an empty glass at this woman that he was having the argument with, his fiancée, and she put her arm up and it hit her arm, and the glass didn't even break, but her arm was bruised. So they found him guilty of that. But on the more serious charges, they found him not guilty on 4 of those. And the point of that story is that he was represented not by David Hoos, not by another expensive lawyer, but by a public defender, Alan Rubin, who's actually the director of that office in Hampshire County. Alan is a graduate of Harvard Law School. He's been practicing for 40 years. He's wearing the same threadbare suit to court 5 days a week. In his alumni bulletin, he's always listed as the least affluent member of his graduating class from Harvard Law. He's never done anything else except practice as a public defender. He's as good a trial lawyer as there is in Massachusetts, or as I've seen anywhere. And this fellow, Hakam McCoy, who's indigent, who cannot afford to hire an attorney, winds up with Alan Rubin representing him for free. Alan is paid by the state of Massachusetts. He gets $99,000 a year. He gets less money than the clerk of court in Hampshire County. And he is representing Hakam McCoy, who has no money to hire a lawyer. And he winds up hearing the words not guilty pronounced by a Hampshire County jury for the first time in 2012. So sometimes you get more than you pay for. And I think the bar advocate system, which I know is under attack by some people in Boston, including Governor Patrick, had some wide-ranging reforms to cut back on this. The practice of having experienced lawyers devote part of their time to representing indigent dependents. I think it's a wonderful system, and I've seen it been working for 3 and 4 months now, and I suspect that District Attorney Sullivan would agree with me that it provides fairness and it comes as close to providing justice as a court of law can do. And I'll let him talk now when we start the panel, and he can disagree with anything that I said that he disagrees with, but I'd like to thank you all for listening to me, and it's been a pleasure to be here talking to you. Thank you.